Cell phones in the U.S. Supreme Court. Hey, you may have heard about the decision that was made by the Supreme Court, at least announced by the Supreme Court on June 25, 2014, in which the court unanimously, unequivocally said that before a police officer can look at the contents of a smartphone, the police officer must have a search warrant. Brings the U.S. Supreme Court into the 21st century, recognizing that cell phones, which are basically everywhere, we all carry them around, have a tremendous amount of information in them. You know, as the decision pointed out, cell phone could as easily be called a calendar, contacts list, camera, whatever. All of these functions that are contained here have all kinds of information in them, or potentially have all kinds of information in them. And the U.S. Supreme Court has now said that information is protected under the Fourth Amendment. You know, when we look back on why the Fourth Amendment came into existence, because the founders of the U.S. said, we do not want government to engage in any unreasonable searches and seizures. We don't want government to come into people's homes, look through desk drawers, pull out information that later could be used in a criminal prosecution. Well, a cell phone, as we all recognize, can carry far more information than could ever be stuffed into a desk drawer in the 1700s. So what does this decision mean to you? Well, if you've watched video blog here in the past, the legal video blog that we present to you every week dealt with a number of issues that arose because of cell phones. One of them was a young man, 21 years of age, who was out riding in a vehicle with a young woman, 17 years of age, stopped for a routine traffic violation. Thought to be a routine traffic violation, and the officer then sees a purse from the young woman sitting on the seat of the car, cell phone sticking out. He begins to look through the cell phone. Well, lo and behold, photos in that phone showing the man, 21, having sex with a woman, 17 years of age. She's under 18. He was then indicted for child pornography. Never expected that to happen, but then they didn't expect those photos to be seen by a police officer. Well, what does this mean to you in your everyday life? Well, what it means is you've got an awful lot of information in your smartphone. And it means that the U.S. Supreme Court has now said that information is protected from unreasonable searches and seizures by government. Remember, the Constitution is about you and government. It's not about you and neighbors. It's about you and government. It's what government can do and cannot do. So, if you are approached and an officer asks to take a look at your cell phone, do you have an obligation to give that cell phone to a police officer? The answer is no. You do not have that obligation. You do have that obligation if the officer can present a search warrant. But in the absence of that search warrant, you hang on to that information. The information basically is information, to some extent, as some people point out, that we're outsourcing from our brain. We have so much information that's put into our cell phone, it's almost like a portion of our brain is being carried around in that cell phone. And all of that information, which you have a right to keep private, is information, as I say, that essentially is almost a part of your brain, and before you would pick up your head, take your brain, and give it to somebody else, you'd give that a lot of thought. Think about the cell phone, your smartphone, in the same way. The U.S. Supreme Court protects your interests, protects your privacy. Okay. We bring you this case, as we bring you cases every week, so you understand how the law works. I'm David Allen.